Osborn and Booth and the Parole Board, and in the matter of James Reilly.
Lord Reid will give the judgment.
These three appeals concern the circumstances in which the Parole Board is required to hold an oral hearing. Such hearings are automatic in Scotland and Northern Ireland, but ceased to be automatic in England and Wales in 2007 for some prisoners and in 2009 for others. The appellant Osborn was convicted in 2006 following an incident in which he was said to have brandished an imitation firearm at the home of his estranged wife. He was given a 6-year prison sentence and was released on licence in February 2009, the halfway point. He was recalled to prison later the same day for an alleged breach of his licence conditions. The appellants Booth and Reilly are indeterminate sentence prisoners who have served their minimum terms. In 1981, Booth received a discretionary life sentence for attempted murder, with a minimum term of 6.5 years. It expired 25 years ago. Reilly was convicted in 2002 of robbery, attempted robbery, and possession of an imitation firearm. He received an automatic life sentence with a minimum term of 6 years and 8 months, which expired in September 2009. Each case was considered on paper by a single-member panel of the board. It decided not to direct the prisoner's release or recommend their transfer to open prison conditions. The solicitors made written representations to the board, disputing its findings and requesting an oral hearing in each case, but those requests were refused. All three sought judicial review of the decisions not to offer oral hearings. Osborn and Booth failed in the High Court and in the Court of Appeal. Reilly succeeded in the High Court, but that decision was overturned by the Northern Ireland Court of Appeal. The Supreme Court unanimously allows the appeals and declares that the board breached its common law duty of procedural fairness to the appellants, and also Article 5, Paragraph 4 of the European Convention on Human Rights, by failing to offer them oral hearings. The Court emphasises that human rights protection is not a distinct area of a law based on the case law of the European Court, but permeates our legal system. Compliance with Article 5.4 requires, in the first place, compliance with the relevant rules of our domestic law. The legal analysis of the problem does not begin and end with the Strasbourg case law. The judgment sets out guidance on complying with common law standards in this context. The board should hold an oral hearing whenever fairness to the prisoner requires one, in the light of the facts of the case and the importance of what is at stake. By doing so, it will also act compatibly with Article 5.4. It is impossible to define exhaustively the circumstances in which an oral hearing will be necessary, but these will often include where important facts are in dispute, or where a significant explanation or mitigation is advanced, which needs to be heard orally in order fairly to determine its credibility, where the board cannot otherwise properly or fairly make an independent assessment of risk, or of how it should be managed and addressed, where it is tenably maintained that a face-to-face encounter or questioning of those who have dealt with the prisoner is necessary to enable his case to be put effectively or to test the views of those who have dealt with him, and where, in the light of a prisoner's representations, it would be unfair for a paper decision taken by a single-member panel to become final without an oral hearing. The purpose of the oral hearing is not only to assist in the board's decision-making, but also to reflect the prisoner's legitimate interest in being able to participate in a procedure with important implications for him, where he has something useful to contribute. The likelihood of release or transfer is separate from the question of whether fairness requires an oral hearing. When dealing with recalled prisoners' cases, the board should bear in mind that they have been deprived of freedom that they've been enjoying. For indeterminate sentence prisoners, increased scrutiny should be afforded by the board in assessing whether the risk that they present is unacceptable, the longer that they have spent in prison after the expiry of their tariff. The board must be and must appear to be independent and impartial, and must guard against any temptation to refuse an oral hearing merely in order to save time, trouble, and expense. The court stresses that paper decisions are provisional. The right to request an oral hearing is therefore not an appeal, and the prisoner need only persuade the board that an oral hearing is appropriate. The common law duty to act fairly is influenced by the requirements of Article 5.4. Compliance with the former should ensure compliance with the latter. Breach of Article 5.4 will not normally result in an award of damages under the Human Rights Act unless the breach has resulted in the prisoner suffering a deprivation of liberty. In relation to the three appeals, an oral hearing ought, following this guidance, to have been offered in each case. Osborn and Reilly disputed serious allegations made against them and had advanced various potentially important explanations which were rejected without investigation. In addition, their requests for an oral hearing were mistakenly characterized as appeals. In Booth's case, input from his psychiatrist at an oral hearing would have been helpful, and it was also relevant that he had spent so long in custody after the expiry of his tariff. Reilly's claim for damages is rejected, since it was not argued that he had suffered any deprivation of liberty as a result of a breach of Article 5.4.